In this session, we will see about how a surety is discharged from his liability. A surety may be discharged by revocation of guarantee, death of the surety, variance in the contract, or release of the principal debtor, or composition with the principal debtor. We will see one by one. Number one is revocation. Revocation is cancellation of the contract. He revokes his contract that I will not be liable from this date. The surety sends a letter to the principal, to the creditor. From this date, I will not be liable for any act of this principal debtor. There are two types of guarantee. One is ordinary guarantee and another is continuing guarantee. Ordinary guarantee is a guarantee given for only one transaction. For example, a person wants to avail a loan of 1 lakh rupees from the bank, repayable in 10 monthly installments of 10,000 each. This is one transaction. Once a guarantee is given, he cannot revoke it because money is given on the basis of his guarantee. Now he cannot revoke it. But if it is a continuing guarantee, the surety can revoke his guarantee. Continuing guarantee means the guarantee is given for a series of transactions. For example, a businessman may go to the bank, avail a loan of 1 lakh rupees. He will avail that 1 lakh, purchase goods, sell it. Sale proceeds will be remitted back to the bank. Again, he will take money from the bank, purchase it, sell it, and the sale proceeds will be remitted back to the. It is a running account, a current account with deposits and withdrawals. The guarantee is for a series of debits, series of withdrawals from the bank. This can be revoked, but the revocation will be effected only from the date of notice. For example, the same 1 lakh rupees he availed a loan, he remitted something, again availed a loan, and one day the surety sent a notice that from this date I will not be responsible for the money given to the principal debtor. If on that day the balance is 80,000, the surety's liability is restricted to 80,000. He is liable for the money availed as on that day. For the liability as on that day will be the surety's liability, but anything done after the date, surety will not be liable. So the surety can revoke his guarantee by sending a notification to the other person. It is not possible in the specific guarantee or ordinary guarantee where guarantee is given for one transaction. If it is for a continuing guarantee, revocation is permitted. Notice should be given to the surety. Effect will be from the date of surety. Future transactions will not be surety's liability, but the surety will be liable for the past transaction. Balance as on that day is surety's liability. Next we will see death. This revocation is dealt with in section 130, death in section 131. Section 131 says that death puts an end to this contract. As on the date, what is the liability? Surety's liability is crystallized. That surety is liable for that amount. He will not be liable for the future transactions. On behalf of that surety, the legal gas will be responsible for making payment of that. But legal gas responsibility is limited to the extent of the property inherited by them. If that person who died, the surety, did not leave any property for the legal heirs, then legal heirs will not be liable for the debt. If they have inherited some property, then only they will be liable for the debt of the deceased person. So surety's liability is crystallized on that death. He is liable up to that point. Because he is died, that legal heirs will be responsible. Legal heirs responsibility is limited to the extent of the property inherited from the surety. Next, section 133 deals with the variance. If the contract is altered without the knowledge of the surety, then the surety will not be liable. For example, there is a contract to pay the money at 5% interest rate. Without the knowledge of the surety, the contract is altered. The interest rate was raised to 20%. Now it is a alteration. It is the borrower has to pay something more. The surety might have given the surety guarantee based on the belief that person is having a paying capacity if the interest rate is 5%. If suddenly the creditor changes the interest rate to 20%, his paying capacity, he may not have the paying capacity. It is a risk for the surety. So anything done which is not beneficial to the surety, then the surety is not liable under that contract, since there is a alteration, variation in the terms of the contract. If it is beneficial to the surety, surety will be liable. If the alterations are minor things, then also surety will be liable. In one case, the banker gave advance to one borrower, another person guaranteed. Subsequent to that, the banker allowed the person to open a second account. All the deposits were made in the second account. Then the court held it is a variation in the terms, so surety will not be liable. Next is discharge of the principal debtor, section 134. If by the act or omission the creditor discharges the principal debtor, then surety will also not liable under that contract of guarantee. For example, a document has to be renewed because of Limitation Act within 3 years. Acknowledgement of debt to be obtained. If it is not obtained, then the contract is not valid. Then the borrower will be escaped from the liability. If that is the case, surety will also be not liable under the contract. If the creditor does anything or omits to do anything, because of his act, the borrower is discharged from the liability, then the surety is also discharged. Best example is the documents of the borrower is not renewed, so it cannot be enforced against the borrower, against the debtor. Then the creditor cannot proceed against the surety because the borrower is not liable, because the contract is not valid. Next is the thing, composition, extension of time, or not to sue. These agreements are with the principal debtor and the creditor, then the surety will not be liable. Composition means making an arrangement between the debtor and creditor and alter the terms. For example, by composition means from this day the period is extended. Originally period was 5 years, now I am giving 15 years extension. It is a composition. They made some arrangements. Anything done without the knowledge of surety, composition, or extension of time, or not to sue, that is a 1 year period for the loan. After the expiry of period, that person, if it is not remitted, creditor should have asked the debtor to pay back. But instead they made an agreement. I will not press for payment now because the documents are valid for 3 years. You take another 2 years. If that is the case, it is a agreement not to sue the debtor. In that case, creditor will be escaping his liability. Creditor will be discharged from his liability. Next is, if the security is not there, originally the debtor gave some security, because of the act of the creditor, the value is lost. Then it is a surety's remedy. Surety's remedy is the security with the creditor. Then the surety will not be liable. One example, one borrower wanted to avail loan from the bank. He is having 100 bags of rice. This was put in a warehouse. warehouse receipt was given to the banker, banker should keep a inspection and see that goods are there. But instead, because of negligence, the goods are removed from the warehouse. Then the security is lost. Surety will be discharged. Another example I will tell you. This person pledged goods. It was a godown kept in the goods were kept in the godown. Keys were given to the bank. But subsequent to that, somebody has taken the goods. Now the security is not there because of the negligence of the creditor. Then this surety is not liable. In the case of State Bank of Saurashtra versus Sitaranjan Ranganath Raja, the same thing happened. Goods were kept in a godown, keys were with the bank. Because of the bank's negligence, the property was removed, the security was removed. In that case, the surety was discharged from his liability. Like this, the surety is discharged on 5 cases. One is a revocation of guarantee, second is death of surety, third is a variance of the contract, fourth is release of the discharge of the principal debtor from the liability. Next is composition with the debtor. In the next session, we will see some other topic.